Good evening. Welcome to Daisy Blue and You. Tonight we're talking before the labels. Law, census, maternal descent, and the ability to rename. Before there were racial labels, before census categories, before blood quantums, and before federal enrollment rolls, we were the Shawnee, the Pequot, the Wampanoag, the Narragansett, the Choctaw, and the Seminole. We were nations, not Indian or Native or colored or mulatto or black. So the question is not whether identity existed. The question is, who had the authority to rename entire people? And how did they acquire that authority? So let's talk federal power and how it was constructed. Federal authority over tribal identity did not emerge naturally. It was built through layered legal doctrine. It started with the Constitution. In Article 1, Section 8, grants Congress the authority to regulate commerce with foreign nations and among the several states, as well as Indian tribes. That clause is critical because it acknowledges tribes as political entities, distinct from state and foreign nations, but it places regulatory authority in federal hands. That is the seat of centralized power. Then comes the Supreme Court in Johnson versus McIntosh in 1823. The decision held that private citizens could not purchase land directly from native nations. The court ruled that ultimate title to land rested with the federal government under the doctrine of discovery. Translation: tribes retained occupancy. The United States claims underlying title. That shifts the foundation of land sovereignty. Then came Cherokee Nation versus Georgia in 1831. This is where the court describes tribes as domestic dependent nations. That phrase still structures federal Indian law today. It recognizes political existence, but establishes dependency. Dependency implies supervision. And then came Worcester versus Georgia in 1832. This was where the court ruled that states have no authority within tribal territories. Only the federal government does. By 1832, the framework was clear. Tribes exist, but federal authority sits above them. Only authority centralizes, administrative power follows. The administrative power includes classification. This is where we move to the census, and the census is a tool of definition. The census was not simply a demographic, it was regulatory. In 1850 to 1860, enumerators were instructed to classify individuals as either white or black or mulatto, and race was determined by observation. So it was actually determined by who was writing it down, not by genealogy or by your tribal affiliations, not by lineage, observation. Meaning whoever was holding the pen and what they saw is what they wrote down. Then by 1870 and 1880, Indian appeared more as a formal category, but typically within reservation context, meaning individuals outside federal reservation systems were often absorbed into a broader racial classification. And this is where we're going to get into that later. I'm going to continue. In 1930, enumerators were then instructed to classify someone as Indian only if they were regarded as such in the community or possessed a degree of Indian blood. This is where blood quantums come in. Identity became fractional. Not clan-based, not nation-based, fractional. Enumerators retained discretion. Entire communities could shift labels from decade to decade and not based on their ancestry. It was administrative reclassification. Lineage didn't matter. Now we're going to connect classification to land, allotment, and demographic control. The Dawes Act of 1887 dismantled communal landholding and replaced it with individual allotments. To receive land, individuals had to be enrolled Enrollment required categorization, and the Dawes rolls divided people into different categories of by blood, freedmen, intermarried white, and those categories had material consequences: land allotment, inheritance rights, political recognition, future enrollment eligibility. It redefined who qualified and who inherited. Over generations, blood quantum standards reduced the number of legal recognized tribal citizens. That's not random arithmetic. It is a demographic structuring through policy. And clarification became a mechanism of territorial contraction. Now we're going to talk about the three legal pillars. We hold these three legal pillars all at the same time, and it completely changes things, okay? In 1662, we have partus sequor ventrum. The baby follows the belly. In other words, whatever the mother is when the baby is born, that's what the baby is going to be. And in 1868, we have the 14th Amendment. And then again in 1924, we have the Indian Citizenship Act. So we're going to start at the beginning. In 1662, colonial Virginia codified the partus secretum ventrum. I know I'm not saying that right, but follow me. This is the child follows the condition of the mother. It's a statutory law. It is the maternal descent or the legal anchor of generational status. By the mid-1700s, every colony had adopted this principle. Maternal lineage was legally recognized long before 1776. Okay, that means descent was structured generationally prior to the formation of the United States. Now, if we move forward, the 14th Amendment constitutionalized birthright citizenship. It regulates political status under the federal jurisdiction. It ensures citizenship cannot be denied based on race, but it does not create ancestry. It doesn't originate lineage. It regulates political belonging. And then in 1924, the Indian Citizenship Act grants citizenship legislatively. That is a statutory recognition, not a constitutional birthright. The constitutional amendment is difficult to alter. A statute can be amended, repealed, and conditioned. So now we have constitutional citizenship and legislative citizenship. Both regulate relationship to the federal government. Neither originates maternal descent. Maternal lineage predates federal sovereignty. Citizenship is political. Lineage is generational. That distinction is foundational. So let's bring all of this together. Over time, census labels shifted, tribal identifiers collapsed into racial categories, administrative sorting intensifies, blood quantum standards harden, but reclassification is bureaucratic, and maternal descent is generational. If maternal ancestry is documented on this land prior to the formation of the United States, that presence is pre-constitutional. The federal government did not create that presence. It inherited it. There is a structural difference between what is granted and what is inherited. Citizenship can be granted. Recognition can be granted. Ancestry cannot be granted. It can only be inherited. The United States can regulate political status. It cannot claim authorship over lineage that predates its own existence. So the bottom line is this. When we talk about the so-called Black Indigenous people of America, we are talking about families whose generational presence on this land predates federal racial classifications. We are talking about communities filtered through racial systems. We are talking about reclassification, not origins. Reclassification does not erase maternal descent. Reclassification does not relocate ancestry. Reclassification alters paperwork, and paperwork is not older than nations. Paper can rename, it cannot originate. It cannot erase generational continuity rooted in maternal descent on this land. Reclassification alters paperwork, and paperwork is not older than nations. Paper can rename, it cannot originate. It cannot erase generational continuity rooted in maternal descent of this land. Before racial labels, we were nations. Before census categories, we were kin. Before blood quantum, we were clans. Sovereignty predates the census. Lineage predates the Constitution. And identity does not begin with a checkbox. So when you look back and see how paper genocide erased a whole nation of people, and that nation of people is the same nation that you can trace your people back to through genealogy, you can see now that you are indigenous to this land, and that those reclassification labels were not your full legal status. So stay with me here, because this is where we talk about your sovereignty. Sovereignty predates the United States. The Constitution did not create tribal nation. It acknowledged their existence. And Supreme Court cases did not invent indigenous political identity. They tried to define its relationship to federal authority. Census categories did not originate people. They attempted to classify them. And classification is not creation. So when we talk about sovereignty, we have to be precise. Political sovereignty in federal law exists within a framework of recognition, treaties, and jurisdictions. But inherited sovereignty, what we are talking about, the existence of people, their lineage, their generational continuity on this land, does not begin with federal acknowledgement. It predates it. The United States did not create the nation it encountered. It encountered them. It tried to regulate them. It tried to litigate them, to categorize them. But it did not originate them. And the distinction matters because reclassification does not erase an origin. Administrative labeling does not dissolve generational continuity. Blood quantum charts do not undo maternal descent. If sovereignty existed before federal jurisdiction, then it's inherent, not granted. Recognition can be granted. Citizenship can be granted. Statistical identity can be assigned. But inherited nationhood is not authorized by the state or the federal government. It's a structural difference. So when the so-called Black indigenous people trace maternal lineage on this land prior to federal formation, that continuity is something Washington can't issue. An inheritance is not authorship. The federal government can regulate political status. It can define enrollment standards. It can alter statistical categories. But it cannot retroactively claim to have created ancestry that predates its own existence. Sovereignty was not handed out, and it was not erased by paperwork. It was constrained, it was litigated, and administratively narrowed. But it was never created by the federal government, which means it cannot be undone by it. Paper can rename, it cannot originate. And if it cannot erase generational presence rooted in maternal descent on this land, before the labels, we were nations. Before the census, we were kin. And before blood quantums, we were clans. And inherent continuity does not begin with a checkbox. It begins before someone else ever even started counting. I would love for you to go check out another video I have. I'm going to tell you a little bit about what we're doing. We're doing a raffle for 4 books that will go with what I'm talking about tonight. These books are Restoring Heritage and Rights, Undrip Empowerment for Copper-Colored Indigenous People by Mark Perkins. I'm also raffling off Roadmap to Reclamation. And this is going to give you a full 360 roadmap for reclaiming your identity, your sovereignty, and land, maybe, if you even have it. It's going to have templates in there that's going to help you create your nation and reclaim who you are. The third book in the raffle is the Reparations Guidebook, Reclaiming Land, Culture, and Rights. This guide teaches how to document your ancestry, assert land claims, protect sacred sites, and pursue repair through lawful framework. And then I'm throwing in my own book, Bloodlines and Belonging, which is a step-by-step guide for genealogy, identity, and belonging. Has 12 steps. It's a roadmap to uncovering your ancestry, organizing your research, and reconnecting your legacy. These books together give you knowledge, tools, and direction to do what you need to do to reclaim your sovereignty, your identity, your legacy. Now, as I said, I'm doing a raffle for these 4 books. All the proceeds goes to support Quest Rescue. I'm the executive director at Quest Rescue. We do anti-human trafficking. We have marked patrol cars on the streets in trafficking hotspots every single day, every single night. We do rescue and recovery, investigation, and advocacy for trafficking survivors and victims. This is a cause that's very important to me. Quest Rescue is a Indigenous owned organization, and we are very aware of the disparities that exist when people go missing, especially the difference in urgency and media attention between the so-called Black Indigenous and their white counterparts. We see it. We acknowledge it. That awareness pushes us to work harder, not selectively, but equally. And we serve everyone, every race, every background, every family. But because we see the disparities, we work harder. You know what I'm saying? Because every life deserves urgency. Every case deserves 150%. And no family deserves silence. So here's how it's going to work. I'm going to do this raffle. You'll get all 4 books if you win the raffle. The raffle is going to go on between now and March 20th, where I will do a live drawing to pick the winner. Each raffle ticket is $1. You will need to send it to the Cash App that I'm going to put on the screen. In that Cash App note section, you're going to have to put a way for me to contact you. Okay? You can enter as many times as you want, but each one has to have that note section filled out so I can contact you if you win. What else do I need to tell you about this? Oh, in order to win, you have to be following me either here. You have to be following me here and on TikTok. You have to like this post. You have to comment on this post. You don't have to comment on the other post, just this post and the other. And then you have to share it, okay? And then you also have to do your $1 through Cash App. We're going to draw and we're going to give these 4 books away, and I'm excited about it. So, and again, every $1 goes to a nonprofit, Quest Rescue nonprofit. So, love you guys. Hope you have a great night, and I hope to see your entry come in, and I hope you win your books. Have a good night.